on the outcome of our judgment unanimously. Bismillah ar-Rahman ar-Rahim. For detailed reasons to be recorded later and subject to what is set out therein by way of amplification or otherwise, these matters are disposed of in the following terms. The ruling of the Deputy Speaker of the National Assembly, given on the floor of the House on 3rd of April 2022, in relation to the resolution for a vote of no confidence against the Prime Minister under Article 95 of the Constitution, for which notice had been given by the requisite number of members of the Assembly on 8/3/22 and in relation to which leave was granted to move the resolution on 28/3/22, and the detailed reasons for the ruling released subsequently and concurred by with the Speaker are declared to be contrary to the Constitution and the law and of no legal effect, and the same are hereby set aside. In consequence of the foregoing, it is declared that the resolution was pending and is subsisting at all times and continues to so remain pending and subsisting. In consequence of the foregoing, it is declared that at all material times the Prime Minister was under the bar imposed by the explanation to Clause 1 of Article 58 of the Constitution and continues to remain so restricted. He could not therefore have at any time advised the President to dissolve the Assembly as contemplated by Clause 1 of Article 58. In consequence of the foregoing, it is declared that the advice tendered by the Prime Minister on or about 3 April 2022 to the President to dissolve the Assembly was contrary to the Constitution and of no legal effect. In consequence of the foregoing, it is declared that the order of the President issued on or about 3rd of April 2022 dissolving the Assembly was contrary to the Constitution and of no legal effect, and it is hereby set aside. It is further declared that the